In January, Sir Ben Bathurst used his authority under Section 66 of the Landlord and Tenant Act. This empowers him to end tenancies when the property being redeveloped is deemed necessary for the public interest for the economic development of Gibraltar. The certificate meant the demolition of the Victoria Stadium could proceed, following objections from the owner of the Murga Bar, who also has 3 kiosks and storage areas in the stadium complex. Clause 66 specifies that this applies to government-owned tenancies. However, the motion filed at the Supreme Court challenges the termination of long-standing rights under the guise of redevelopment in the public interest. Allan Asquez is suing the government responsible for the policy and decisions in the motion, the Office of the Governor, which issues the certificate under its constitutional authority, and the Attorney General, the principal legal officer under the Constitution. Lawyers Gomez & Co., acting for Mr Asquez, sets out its case as follows. Section 66 of the Landlord and Tenant Act lacks procedural safeguards, compensation guarantees and the judicial oversight required by Section 6 of the Gibraltar Constitution. This, it says, is the supreme law in Gibraltar which provides protections of rights over properties. The European Convention of Human Rights states any interference with property rights must include fair procedures, adequate compensation and judicial oversight. The Landlord and Tenant Act provides for the right to renew leases, termination and compensation procedures, and an extension of tenancy. The motion asserts that Section 66 seeks to override these protections without adequate safeguards or compensation. Furthermore, Mr Asquez claims the Victoria Stadium is already in the possession of the GFA and not the government. However, this is disputed by the government, which says it only assigned the GFA development rights for the stadium. The claim also points out the governor is not subject to any of the impartiality and procedural safeguards inherent in judicial proceedings and does not operate within a structured adversarial process where evidence can be rigorously tested. It states the role of the government as both landlord and the de facto decision maker through the governor also creates inherent conflicts of interests. As regards the reason for issuing the certificate, that it's in the public interest for the economic development of Gibraltar, the claim submits that this is vague and subjective and fails to define clear criteria. Mr Asquez seeks the following relief from the court: to declare that Section 66 of the Landlord and Tenant Act is inconsistent and incompatible with Section 6 of the Constitution and is therefore void. To declare that the certificate is null, void and of no effect, and to grant any further relief deemed by the court to be just and equitable, including but not limited to Mr Asquez's costs. GBC has contacted the government for its reaction to this motion. It says its position remains exactly as stated previously and it will strenuously resist any application made by Mr Asquez that seeks to advance his exorbitant claims, which would be contrary to the common interests of the Gibraltar taxpayer. The respondents have requested an extension to file their response and evidence. This has been granted for a period of 28 days until the 25th of February.